3, 2, 1.
This Honorable Court of Appeals is now in session.
Thank you. Good morning and welcome to the Tennessee Court of Appeals. A couple of preliminary matters. The presentation will be presented as if we were actually in court, except you will not need to rise to present your argument. The next thing is that if there is any technical difficulties that develop during these proceedings, please let us know immediately so they can be addressed. Now, what is our status on this particular case? I received an order on this case that the appellant was going to waive or not going to waive, or what is the status?
I'm sorry, Your Honor. This is Amanda Morse on behalf of the appellant, Knox County Sheriff's Office. I made a motion to continue the hearing that was denied, and I'm ready to go forward. I have strep throat, so if you can't hear me, that is why.
We can hear you very well. Thank you very much. Okay. If there's no other preliminary matters, Madam Clerk, will you please call the case?
Meghan Conley versus Knox County Sheriff et al.
Thank you. For the appellant, you may present your argument.
Thank you, Your Honor. Again, my name is Amanda Lynn Morse. I'm here on behalf of the Knox County Sheriff's Office in this matter. And what we have today is a pretty straightforward 2 issues of law, I believe. The first issue is, did the trial court fail to properly consider the 2008 amendment to the Tennessee Public Records Act, which requires that any request be sufficiently detailed to enable the governmental entity to identify the specific records for inspection and copying? And then whether or not the Chancery Court erred in determining that once a willful violation is found, it has the authority to issue award attorney's fees for all of the issues, not just those that were willfully denied. Knox County is not disputing the factual findings of the Chancery Court. There was an exhaustive hearing process, several days. We believe all of that has been fully addressed. What we are disputing are the legal conclusions reached by the Chancery Court, which we also assert, obviously, that requires a de novo review. At issue is paragraph 3 of the court's memorandum opinion and order, which states that from here henceforward, the Knox County Sheriff Office is prohibited from treating a written request to inspect or for copies generally phrased in terms of information sought as insufficient for lack of specificity or detail automatically, because the written request is generally phrased in terms of information. In essence, the Chancery Court says the Sheriff's Office can no longer deny a generally phrased request as lacking sufficient detail in accordance with Tennessee Code annotated 107-503A4. The Chancery Court specifically stated that they believe that requests that are generally phrased would meet the standards set out by the legislature. And Knox County disagrees. The legislature in 2008 deliberately added these words: any request for inspection or copying of a public record shall be sufficiently detailed to enable the governmental entity to identify the specific records for inspection and copying. From that date forward, any request that was simply generally phrased in terms of information, a public records request about all water, or any issues regarding electricity, or in this case, any IGSA, should not meet that standard.
Ms. Morse, is it your position that anyone requesting a public record has to specifically identify the record in the form that the Sheriff's Department keeps it?
No, ma'am.
Okay. So
Yeah,
what?
We are merely saying that they have to provide us with enough information that the request should be sufficiently detailed so that we can identify the specific records. So let's say,
they want documents regarding the I forget the name of the ICE program, but if that's what they're saying, we want all documents related to the ICE program. Why is that not sufficiently specific enough for the sheriff's department to find those documents?
Because that's the equivalent of saying, I want all documents regarding arrest in Knox County Sheriff's Office. It's simply too broad, because do they mean they want arrest reports? Do they want invoices? Or let's go to the 287G contract. Do they want invoices? Do they want production notes? Do they want any emails sent to ICE? Do they want emails received from ICE? Do they want federal warrants? Do they want to know how many beds we built using ICE money? Do they want to know how many papers or documents regarding ICE? Basically, a request that says, I want any record about the IGSA or the 287G program requires the sheriff's office to go through every possible record it has to determine if it's related to the IGSA program. And governmental entities are not required to sort through piles or search for that sort of information. However, a request about something, for example, invoices paid by the 287G program, that's a specific, easily identifiable category. We can go get those records. Arrest warrants issued in pursuance to the 287G program, that's a specific category of records. We know exactly where to go. The trouble is a lot of times citizens view governmental entities as if they are very small offices. The sheriff's office has 5 different buildings, 1,100 employees, an equal number of email accounts. We have countless contracts. It's not as simple as if a plaintiff wanted to say, we want the law director's office on the Conley, the Knox County Sheriff's Office case. I have a folder sitting on my bookshelf here about that. I can pull it, go through, redact information. So it's just too broad of a topic. And that is really the issue here, is that plaintiff has been requesting a topic, which under FOIA, if we are a federal entity, would be sufficient. But Tennessee has chosen to say you must have enough detail, sufficiently detailed, for us to identify the specific records. And in its ruling, the court relied on Hickman, which has some language about how generally phrased is sufficient. I would point out that I don't believe the Hickman case stands for that. That the request made in Hickman was actually very specific. And there was no evidence about why it wasn't specific enough. But that case was before the 2008 amendment. The Open Records Council themselves have acknowledged twice that Jake's in the 2008 amendment have probably overruled that case. It's been superseded by statute.
Ms. Lawrence, let me make sure I understand. I mean, you have an argument with the injunctive relief that was granted here, but you aren't arguing that under the Public Records Act, the trial court can't grant some form of injunctive relief, are you?
Well, Your Honor, the court specifically in his memorandum and opinion didn't call it injunctive relief, said that they weren't going to grant it. The court didn't analyze any of the injunctive relief factors like irreparable harm or likelihood of success. None of that is discussed, so it's unclear if he was attempting to issue an injunction. I do, however, believe that because the court based their ruling on the idea that anything generally phrased in terms of information would meet the standards set by the Tennessee Code Annotated, it made a clear error of law on that issue. If it was attempting to issue injunctive relief, it has now made Knox County Sheriff's Office the only entity in the state of Tennessee that cannot follow the statute and require, has the Tennessee legislature intended for citizens to be specific and provide sufficient detail for us to identify specific records. No other case has gone as broad as this. So like the sub issue there is it injunctive relief? The court made no factual findings about any of the factors as required by Tennessee law. And if they did try to injunctive relief, it was clear error. He's basically saying that the Tennessee statute is wrong and that his standards should apply. And I believe that's a clear error of law. Likewise, I see I'm running out of time. The attorney's fee issue is very direct. There were 12 public records requests at issue in this case. The court determines that the Knox County Sheriff's Office has willfully refused to disclose records in response to 2 of those records requests, but not the other 10. Therefore, if the court wanted to use its discretion to award attorney's fees, it had to limit it to just fees involved in obtaining or litigating those 2 records requests. It is clear under the case law that if something has not been willfully denied, you do not get attorney's fees. And I understand the plaintiff's contention about you have to look at the whole case or intertwines theory or common core effects. None of those are the standards set by the Tennessee Public Records Act. And if the plaintiff was unable to proportion out their own attorney's fees, they should have either been denied entirely or limited to 1/6, because they only won 1/6 of their issues. The other ones were not willfully denied.
In your statement of issues, Ms. Morse, you don't raise an issue about the fees on fees. Is that correct?
No, Your Honor, it's just part of the issue that they should not be allowed for records requests that were not willfully denied. There is certainly case law that says once you were still arguing willfulness, that's what happened in Little. They went all the way up and they were still arguing about whether or not it was a willful denial. Those fees may be appropriate, but I do not believe there is any standing for awarding fees purely for seeking fees, as Mr. Rifkin did in this case. Thank you very much.
Thank you.
Okay.
You have your rebuttal time. We're going to have 2 arguments for the appellee or 1.
Your Honor, we'd like to divide our time. So I'd like to take 9 minutes to discuss the issues of specificity and topic of willfulness. And my colleague, Professor Rifkin, will have 6 minutes to discuss attorney's fees.
Thank you very much. Okay. You may proceed.
Thank you, Your Honors. May it please the court. My name is Andrew Fells of the Knoxville Bar, and I, along with my colleague, Dean Rifkin, represent the appellee, Professor Meghan Conley. As I said, I'd like to divide my time. I will be addressing the topics of specificity and also the issue of willfulness. However, before I delve more deeply into those issues, I'd like to point out a few points of rebuttal. First, the sheriff does not contest the factual findings that Chancellor Weaver made. Where is the factual finding that the records custodians could not identify specific records based on the details provided by the requests? That's the finding that they need. That has not been pointed out in the brief. Second, as to injunctive relief, the issue of injunctive relief was not properly raised. The sheriff's first issue discusses whether 107503 has been properly applied. Remedies under the Public Records Act, that's under 107505. I believe under Schneider versus City of Jackson, it's also quite clear that there's nothing inappropriate about awarding injunctive relief, and nor is there anything inappropriate with awarding attorneys or appellate attorneys fees associated with that injunctive relief. Schneider versus City of Jackson, 2007.
Mr. Fells, my question is, what the court's order says, KCSO is prohibited from treating a written request for inspection or copies generally phrased in terms of information sought as insufficient for lack of specificity. Like, who determines whether it's generally phrased in terms of information? So that just seems like such a nebulous standard for the sheriff's department to try and figure out, is this generally phrased, or is this asking, how's that workable?
Yes, Your Honor. I've thought about that a lot. And in Hickman, and the court is drawing that language directly from Hickman, the inmate there was asking for, I think it was 14 different categories of information from the parole board. Ultimately, the way to square the court's order and the specificity requirement is to look to the factual matter of whether or not the record custodian could read the request and whether there's sufficient detail there allowing them to then identify those records. So it's really case by case. And here, this order is not saying that the sheriff is incapable of denying records requests generally phrased in terms of information sought. Well, what it's really trying to address is the sheriff's policy of denying records requests that are sufficiently specific based on their use of the words any and all. And that was something that cut across this case. And indeed, there's ample evidence to show that the sheriff actually did understand these requests. Once the order was in place in July of 2020, Professor Conley again exercised her Public Records Act rights to request documents related to the ICE KCSO communications. In return, she received 200 pages of documents. And this is on pages 24 and 25 of the appellee's brief. In those documents were, actually one of those documents, page 957 of the trial court record, was actually an email that was written by Mike Rubel, the sheriff's chief counsel and key witness at the hearing and record coordinator. It was written by Mike Rubel in 2018 to ICE discussing the IGSA contract. And in that email, Mike Rubel says, this contract is being forwarded to the Knox County Law Director's Office. At the August 6, 2020 hearing, the Sheriff's Counsel admitted, yes, I know that there are lots of IGSA related documents, and also admitted that the records that were turned over were in fact responsive to Professor Conley's prior request. So really, I think the real question here is, can you identify records based on the details that are supplied in the request? Here, the answer is yes. When the trial court order was in place, that's when the records were finally turned over. But
so if the request is, I want any and all documents related to the ICE program, is that specific enough?
Is that specific enough? I think, again, that's more of a factual question regarding what is it that the record custodian can actually identify. And as Chancellor Weaver is quick to point out, a lot of this can be solved through the application of common sense and communication between the parties. If the record custodian comes back and says, I'm not quite sure what you're asking for, does this work for you? Can you provide further specifications? That helps achieve the end goal of the Public Records Act of ensuring public access to government records in the interest of citizen oversight. What happened here was, it is claimed that these requests simply weren't specific enough. And yet, rather than trying to figure out what was actually being requested, they were just denied totally, even though the sheriff's chief counsel was communicating with ICE at the same time that the sheriff was denying Professor Conley's request for ICE KCSO communications.
If I remember correctly, one of the reasons for denial was the records custodian thought they were asking for unredacted documents, or for redacted documents, and they didn't have those, and that was the basis for denial, when in fact that was the source of confusion. And so it's your position, if they had, that's not what we asked for, number one, and number two, if you had just communicated that to us, we would have let you know what we really wanted.
Yes, Your Honor, and on the issue of redaction, that was an ex post facto justification. Chancellor Weaver clearly makes the factual finding that in regards to the arrest reports and the emails more than 30 days old, those were denied for factual reasons. And under 107503, in your written denial, you've got to provide the basis for the denial. And as in Friedman versus Marshall County 2015 illustrates, what we're really looking at is, what were the reasons given at the time? Because you can't come back, as the sheriff did in Friedman, and give ex post facto justifications and saying, well, I thought this was actually, they were asking for redacted records, or you can't do that. That's not permissible. And that's what is happening here is the sheriff has tried to present these additional defenses. But again, because these aren't actually legal issues, typically willfulness is just going to look at the matter of, did you have a good faith argument for why you denied that records request? Here, no legal arguments were presented at the time and aren't even really being presented now. It was purely factual. We don't allow inspection or arrest records. We don't have emails more than 30 days old that we can access. And that's simply, that is factually mistaken in regards to the emails. And of course, under the Public Records Act, inspection is the most basic form of access. You can't blanketly deny folks access to arrest records. And so ultimately, the trial court was correct in finding 2 willful denials. Again, as discussed on page, I believe, 23 of the appellee's brief, there are actually at least 8 different Public Records Act violations that were found, although only 2 of those ended up being willful. In closing, I see my time is nearly up. I ask that this court affirm Chancellor Weaver's decision.
Thank you, sir.
Thank you, Your Honor.
Mr. Ranking? Yes, sir.
You. May it please the court, my name is Dean Rifkin of the Knoxville Bar. Just as the sheriff designed a public record system that was designed to circumvent compliance with the Public Records Act, the county on the issue of fees is seeking to circumvent the established standard of deferential review of attorneys' fees. I'll argue that Chancellor Weaver's award of fees is supported by 1, the record, 2, the text of the Public Records Act, and 3, by controlling case law, and that the case should be remanded for a determination ultimately of fees on appeal and for post-judgment interest. First, the record. Chancellor Weaver presided over extensive post-judgment proceedings. The proceedings related to attorneys' fees involved briefing, it involved hearings, it involved evidentiary matters, cross-examination. Not once did the county put on proof contradicting the meticulous timekeeping and meticulous documentation of counsel's record. Chancellor Weaver's decision followed several months later in November of 2020. And Chancellor Weaver's decision was scrupulous in its adherence to the Tennessee Supreme Court standards for determining attorneys' fees. And of course, Chancellor Weaver is an experienced trial judge. He has experience with fees. His discretion, as I'll talk about in a minute, includes understanding of local practice. He did not abuse that discretion, as that term is used in the context of statutory attorneys' fees. He went through all the factors in Rule of Professional Conduct 1.5. He made findings of fact. He went right by the book, and he came up with an attorney's fee award that is within his sound discretion.
Let me ask you.
Yes, Your Honor.
Is that decision consistent with our opinion in Friedman about when you allow attorney fees?
Yeah, yes, it is, Your Honor. The Friedman case is consistent with what Chancellor Weaver did.
Friedman, we denied attorney fees for the requests that we found were not in bad faith, even though they were requests that should have been honored, but because there was an arguable reason to not provide it.
Yes.
We said that refusal was not in bad faith, and you get no attorney fees in connection with that request.
In Friedman, as Your Honor just said, there was a good faith argument to be made that the law had not required those kind of disclosures. Here, there is no basis for saying that. The law, we believe, is quite clear that the public records that were being requested should have been disclosed. There's no Friedman ambiguity, if you will, on that question.
But here-
Two of
Go
the
ahead.
requests, I'm sorry, Judge Armstrong,
No, go right ahead.
but the other ones, the court said there was no bad faith denial. So, I mean, like what they're saying is basically you're only successful on a small portion of your request for public records. So why should you be given all of your attorney's fees when you weren't successful, but on a small percentage of your requests?
Yes, Your Honor. As we explain at length in our brief, the decisions of this court that have dealt with statutory attorney's fees and have dealt with issues as to when claims are even lost, and in the context of these fees, they have said there is no proportionality. There is no mathematical formula to be made. This is within the discretion of the trial judge. And the trial judge here was intimately familiar with what occurred in this case. And what the trial judge said, I think his phraseology was the best. He said, there is a blanket over this whole case that counsel for the plaintiff had to litigate. And each claim, looking at each claim mathematically is just not consistent with the precedents of this court that we cite in our brief.
But in hearing this
Yes.
case, Mr. Rivkin, as to each request, there was a separate hearing, and there were a total of 12. On 10 of the 12, you lost. Why do you get fees for all of that time involved in presenting those 10? Well, suppose it wasn't 10, suppose it was 50, and you only got 2. Do you still get all of your fees?
You get all of your fees if the claims are interwoven. In other words, Chancellor Weaver saw each claim in this case as being connected to each other claim. And as my co-counsel said, there were 7 violations of the Public Records Act. Each of these claims shed light on the other. And the case law on this question is quite clear, and they are explained in our brief.
But in his first order, he didn't see it that way, did he? In his first order, he only granted fees on the 2 claims, on the 2 requests that were unlawfully denied.
He did. He did not have any, at that point, proceedings on attorney's fees. He didn't hear the proof of Mr. Fell's testimony. He didn't hear argument. He had not looked at the cases that this court has decided on this question of proportionality, rejecting proportionality and looking at the results. And that's what 1.5 of the Rules of Professional Conduct require the court to do. And they say it's within the discretion of the trial judge. And it should be, because the trial judge is intimately familiar, and that's where the abuse of discretion standard comes in.
Thank you, sir.
Thank you.
Anything further? Then you have your rebuttal.
Thank you, Your Honor. Just to be brief, just to hit a couple of the points. After this case, Dr. Conley did not make another request that just said for anything related to the IGSA and received documents. Plaintiffs have made that contention as proof that the injunction or not injunction is working. What Dr. Conley actually requested was copies of all KCSO invoices sent to ICE under contract number, and identified where those invoices are described in the contract. She also then requested emails sent between Hugh Holt, Mike Rubel, Mitzi Evans, Terry Wishire, and any ICE employee in a very specific date range. What happened is Dr. Conley has now made appropriately sufficiently detailed requests, and she received those documents. And that's from her own affidavit. It's page 952 of the technical record that was attached to plaintiff motion to supplement. It's just she did not just suddenly start getting any record regarding IGSA. She made requests for specific categories that the Knox County Sheriff's Office was now able to identify. Moreover, in an ideal world, we would always be able to follow up with the requester about more specificity or what you were doing or what were you actually looking for, but the law does not require that. The Knox County Sheriff's Office gets thousands of public records requests, and it cannot follow up with everyone. And the law doesn't require that they ask the requester what they mean. Instead, the burden is on the requester to be sufficiently detailed to identify specific records. That's their burden to meet. Then the Sheriff's Office can identify the specific records and provide them, which also happened throughout this case. We're talking about these 12 records, but this went over for several weeks. She received lots of documents. In response to most of those, she said were denied. As to the issue of litigation willfulness, I will point out that there was an issue about the arrest reports. The court made a finding of willfulness. In testimony, the Knox County Sheriff's Office public coordinator said that she thought Dr. Conley wanted to see unredacted arrest reports, which are not publicly available because redactions must be made. And then Dr. Conley never followed up. I don't believe that a mistake or a miscommunication meets the standard of willfulness, but that's where it is. Regarding attorney fees in general, the court's discretion kicks in for the records it is found to be willfully denied. We can talk about blankets, we can talk about interwoven theories. In both of his opinions, the court still consistently said it only found a willful refusal to disclose in 2 of the 12 issues. I certainly would not prefer a mathematical organization or division. It was the plaintiff's duty to keep his attorney's hours divided by the issues, so that way he could present the court with the information it needed to award appropriately. Absent them doing that, they kept meticulous hours, but they didn't bother to identify any of the issues or which specific one it was made. And these 12 issues were argued in a hearing one at a time. We presented evidence and arguments about LUR A1, then LUR B1, then LUR B2 for several days. Counsel could have easily divided his time appropriately and kept track, but he didn't. So absent that, the Sheriff's Office believes that they failed to provide the court with the right information and should be denied fees entirely. If fees are to be granted, they should be limited to at most 1/6. And that's just because they didn't provide enough information. And the Friedman case is exactly on point. There were 2 issues. This court then limited recoveries to only the settlement agreements because it reversed the trial court's finding about willfulness on the settlement reports. Likewise, in Schneider, when this issue was analyzed, this court analyzed it on an issue by issue basis. And then as to fees on fees, it's the plain language of the statute is clear. You get reasonable cost involved in obtaining the record, not any records, not all records, the record denied. None of Mr. Rifkin's actions have been about obtaining the record. That was already litigated and decided much before he entered the scene. That's all I have on that, Your Honors.
Again, a couple of things on the injunctive relief. I'm looking for a statement of that as an issue in your brief. I don't see it. As to the fees on fees as a stated issue, I don't see that either, Ms. Morris. How do I?
We did argue it as a subcategory of that the court made a clear error when it determined it could award any fees for things outside the records willfully denied. It is an element of our argument. We did not set it out as a separate issue. Likewise, for the injunctive relief, it was difficult to put it as its own issue because we are unsure if the court was ordering injunctive relief when it did not analyze any of the injunctive relief factors whatsoever. That is why the Sheriff's Office is arguing that the court did not properly consider the 2000 amendment. in issuing its order.
But clearly, the
2008
order
amendment.
said that you were enjoined from using the request as being not specific enough as a default basis for denying a request for any and all records. That's
It
part
didn't-
of the order.
the court did not use the word enjoin, and without those factors, it was hard to identify it as an injunctive action. We believe they committed clear error of law if it's an injunction or not by ordering that. But I didn't want to be disingenuous with this court by making it an issue when it appears the chancellor was not attempting to issue a preliminary injunction or an injunction because he didn't look at any of the 4 factors. It was a pickle that we were in, and we made it a subset of our general arguments that he is ignoring the language of the 2008 amendment and relying solely on Hickman. Because generally phrased in terms of information should not be sufficient to meet the standard set by the Tennessee legislature, that all requests be sufficiently detailed to enable the governmental entity to identify the specific record.
Thank you. Mhm.
Right.
Anything further? Any other additional questions from the judges? And thanks to the attorneys for your presentation. Your case has now been submitted to the Court of Appeals. You will receive our opinion and ruling on this case within a due course of time. Thank you, Madam Clerk.
This honorable court is in recess until 11:30 a.m.
Thank you. The lawyers may be excused. Thank you very much.
Thank you, Your Honor.